or in part to some of you even as consumers of these products and tools. So thanks you all for coming out in the middle of midterms, I think. Yeah? I am interactive, so if you have a burning question, as Carter knows, you can raise your hand, and I will probably write your name on the board and maybe even give you points, and at the end, there is no prize except for clout with me for anybody who gets the most points, so just be aware. There's also been a dunk tank before, so don't be a heckler, or do, depending upon how you're wired. But anyway, it's great to be here. I'm a partner at Fox Rothschild, which is a nationwide, really international law firm. We're in the AmLaw 100. And I practice corporate law, AI law, cybersecurity, data protection and privacy, and IP law. And I have to kind of practice all of those laws to have the Venn diagram overlap for serving product-driven companies and inventors in this time. And so most of my clients are in the software space, software hardware. I'm doing more drone and aviation, and then also in bioengineering, biotech. A little bit of entertainment and sports law, but mostly when folks are doing well in those fields, they cross over and want to start other businesses or invest in them. So for instance, I helped start and relaunch the Arena Football League last year. So structuring that, putting that together, putting the governance in place, stuff like that. So that's kind of fun. Why are we talking about AI law? Well, it's kind of, it's a good topic. Everyone's kind of interested in it. It's also a bleeding edge area of law, so I just love talking about it and having the excuse to spend more time in it. And yeah, why not? Here we are. Okay, has everyone had pizza that needs it? Sorry guys online, gals, you're out of luck. You should have come. I'm gonna not eat, so if I pass out, then just feed me pizza and we'll keep going. But let's talk about it. So AI law. First and foremost, I just described to you how my practice area, oh, yes, sir. Hello. Yeah. Trying to get a new marker, or should I have one? Yeah, I love it. By the way, tell me your name one more time, because Amadou. You always come, you always participate. You definitely, thank you, ma'am. How do I spell that? And then, ma'am. T-Z-I-P-I. Got it. All right, we got our first two up on the board, just for participating. Cool. So AI law. So AI law is actually a lot like my practice area right now. It's sort of a made-up area of law, except it's not. So what does it mean when I say that? It means any US law, whether it's federal, state, local, that actually uses the phrase artificial intelligence in it. And then it also means any existing area of law, right? So AI-specific law or other areas of law that directly implicate the business of producing AI and then providing services to end users in AI, right? And so that can be IP, intellectual property, and I'm gonna go fast through a couple of things, but if you don't know, like if you've never encountered this term, has anyone not encountered intellectual property? Do you know does anyone want me to just say quickly what it includes? Thank you. So intellectual property in this case includes copyright, which is any idea that you put into a fixed medium. That could be a song, a performance, a writing, code, a painting, a sculpture, even a choreography of a dance. That's a form of intellectual property, copyright. There's also trademark, which is not this great idea you put in a fixed medium, but a specific logo or brand or slogan that is associated with a specific company that produces something. And the reason why that's valuable is not because it's such a great logo or such a beautiful piece of art, but because it's associated with you, the consumer, with that quality level of that brand. And so if anybody else borrows it or steals it, they're basically taking your goodwill that you've built in the marketplace for the quality of your brand and what you're doing. So we don't want people to do that. That's trademark. And then finally, patent is the one that most of you in the room are probably familiar with, heard of, maybe even filed before, a provisional or non-provisional. Has anyone actually filed a provisional or non-provisional patent before? Good, sir. Yeah, fun stuff, right? Yeah, for sure. Super fun. So patent. And when it comes to AI, the hot area of, can you guess which is the hottest area of controversy right now in these three? What would you think? Ooh, someone said trademark. Anybody else have a guess? I mean, that's not wrong. Huh? Copyright? Anybody else? Got one and one? Yes, and I should say, I didn't describe patent. So patent is the way something works that is a new way of doing it, or the purpose it serves is a new purpose or utility. And so it doesn't matter how beautiful it is or how wonderful it is. It doesn't matter if it's associated with a brand. Just what it does is the patent part. So yeah, so AI, generally we're talking about GPT, LLM-backed GPTs. We're not talking about natural neural networks here so much yet. We're not even talking about quantized, quantum computing driven AI yet. Most of the time we're talking this year, this is the hot area of law. So I think it was Carter. Yeah, you're throwing that out there? But for old time's sake, back on the board, I love it. He used to just dominate the board. Like, yeah. I mean, he's back. He's defending his title. Okay, so it's copyright. And in fact, the one thing I can tell you to start off the whole thing is, it's law, it's kind of dry. We had 2 people fired from the leadership of the Copyright Office this year in May by the administration because they wanted to put out an official statement about what the Copyright Office thought about whether AI could leverage other people's copyrighted works en masse for training data and how they should do that. And the head of the Copyright Office was axed before that could come out. The second in command put out the report before it was fully cleared as a unofficial, non-binding, but just, hey, here's what we think. She was then canned almost immediately. She sued to get her job back, saying it was unlawful because, this is just fun for me to talk about. So the Copyright Office sounds like an executive branch thing, and then there's the executive branch run by the president. There's the legislative branch, which is the Congress, right? And then there's the judicial branch, the judges, the court system. The Copyright Office is actually not under the executive branch like most of these other departments that you hear about. It's actually a function of Congress because Congress has the Library of Congress, and that is the main archive of all intellectual property records of the documentation that you would send in to prove that you made something or built something. And so can the president even fire the leadership of that? Because that's a congressional duty over there. So then she's fighting. She got put back in place by the DC court a few months later in September. Now there's 2 people in that role. We're not sure who gets to review what and decide what the policy is. It's just very exciting for us lawyers. And that's going to the Supreme Court. The Supreme Court has decided to review this case, and we're probably going to get an answer on whether the president is allowed, the executive branch is allowed to use his executive authority to go into the Congress and make hiring and firing decisions and sort of take over core elements of congressional research, congressional activity related to this stuff, including the legislative service, which is the main body that basically drafts the first drafts of the bills that come when they're not drafted by lobbyists, but that's another thing. And so when they're fully drafted to be reviewed and edited and debated, that's a congressional office, and there's been talk about the president office or the White House wanting to be able to decide who the leadership is in that or have review of that office that would give the president effectively the opportunity to see before any bill becomes publicly discussed and debated. Legislators need the ability to just ask for research to be done and for that copy to be put together. Sometimes that's quite confidential. They want to do that, they want to research before they then present it to the public. And then that would allow the executive branch to see in, which is a core function that is typically confidential for Congress people. So we're going to get an answer from the Supreme Court potentially this year on that division of power. And I'm excited because I don't know how this court is going to rule. And it's just very exciting. Not an AI topic per se, but it will affect also the Copyright Office issue that we have. Yes? What was their standing or their stance? Yeah. They want to be put back into their position. What was their report? Yeah, we're going to get there. I promise. That's the core law we're going to talk about today. So So yes, I will talk to you about it. I will, yeah, so as a teaser, there's some contours there of how it goes. Okay, so where are we? We have AI law is directly quoting AI. We have intellectual property. My marker still doesn't work. Maybe it's me. We have a whole box. We have data privacy and protection law that implicates AI usage because of just input that you're putting in if you're a student, if you're putting in protected information, healthcare information into these tools, or if you're training with that information. And then we also have, let me see, what was I going to say? Oh, cybersecurity, big issue right now. So there's a patchwork to a certain degree in the United States on cybersecurity law on the federal level. We do have the NIST framework, which in effect is enforceable not because there's an agency like NIST enforcing it or the DOJ, but because it's become industry standard for most software applications in commerce. So if you aren't meeting that framework of the NIST framework for cybersecurity, then you are probably going to be held liable for having improperly run your business. So all of you who have software products and services, if you haven't taken a look at the NIST framework, I talked about this briefly in my last talk. It's just a great, it's long, but you can also boil this down with a GPT and get a summary checklist. And it's a good framework for you to just know I'm meeting whatever requirements there are in most states, because a lot of states have basically taken this and codified it into law if they've actually made it enforceable, with their state level departments being able to fine you or giving consumers a private right of action to bring a lawsuit on their own against you for damages if you're not following a system for cybersecurity similar to this. And I emphasize this here because very often when you're moving fast and breaking things, I understand that you're not thinking about cybersecurity so much. You're just trying to launch your darn MVP. You're just trying to move to prod and like get that thing out there and get some users and validate. But if you haven't at all considered how that user data is going to be collected, where it's going to go, who's going to get it, if your sole plan for monetization is to have affiliate data sharing or advertising, you probably need to read this or just have a summary and just double check that what you're doing isn't inherently going to create all kinds of legal risk for you the moment that you get real traction. Make sense? Okay, so that's another area of law. What else did I say that I do? I mean, there's a lot of corporate and contracts law in here. I'm going to say energy law is the dark horse that's kind of come up in relation to AI law in general. This is less relevant to you guys today, but there's a couple thoughts I have on that I wanted to share. So this is what it is. And so what we do is we live in this, like AI law exists in like the Venn diagram of like these 6 areas of law. And it's kind of here, and it's creeping into here, and it's going here. And we're not sure how broad and expansive it's going to be, but I would say that as a result, it's starting small, but I think it's going to creep out more and more and more into IP, right? So if IP is here, I think IP law is going to be a big area of expansion. And I think data privacy and protection is going to catch up more and more and be defined. And as we start applying this more directly to AI and like naming and updating laws with AI elements, I don't think they're going to carve out. I think they're going to actually expand more responsibility on how you build AI tools to make sure that they have data privacy and protection. I think for IP, well, let's talk about that. How is this going to get more expansive beyond? Is it going to just create a lot more burden for you, or is AI going to get a free pass for fair use more and more? Let's talk about that. So I'm going to talk a lot about this tonight. I'm going to talk a lot about this. We're going to talk, as far as I'm concerned, for this, we're probably not going to talk much more about it. This is my big takeaway. If you don't learn anything else tonight, make a checklist for yourself on the NIST framework. Make sure you're in compliance with it. And then for patents, I think we're going to end up kind of covering it by extension and maybe a smidge of trademark in that. And then we'll just talk about overall what's existing. All right, how are we doing? That's a lot. Yeah?
So you said like it hasn't.
Yeah.
Could you elaborate on like what hasn't been
Sure. So a lot, so it does. And the reason why I say there's an overlap here of these areas of law, and they do already create, even without naming AI specifically, legal requirements if you're building AI platforms, tools, agents, any of that, is because if you are doing the other functions that are covered by those laws, if you're making a database, a CRM database, if you're making, if you're collecting consumer data, user data, that triggers any of the existing data privacy laws on the state level, which is often the most important, or on the federal level in the United States, but even more abroad, nationwide or continentally wide in the EU and specifically in the European Commission under GDPR, then you're worrying about this. But I do think that as we are learning more and more about having more, I want to get there. Can I come back to this?
Yeah.
I want to get there because I want to talk about logs and like where I think the requirements are going to go as far as input logs for AI applications, both who are the GPT creators as well as those who are the agentic layer creators. If you're doing additional training and inference training, and you might have to start, I guess the short answer is I see a trend where we could have more jurisdictions require that you have a lot more transparency about logging every source of that data that you used for those purposes. And then if you're doing this for, let's say, patient care or claims processing for health insurance claims, which are big areas of growth. Or if you're building a legal app, right, like legal services app, there's a ton of confidential information that's going in there of all your different clients. And you are a client of the app, and you would expect a certain level of confidentiality to apply to the information that you're putting in about your business and your customers into a legal services app that's generating documents for you. That would trigger potential data privacy requirements in certain states and jurisdictions. And certainly every state under a state bar, if she decides to treat her application as a law firm, it's just a digital law firm, instantly every state bar is like a regulatory body that she has to comply with when it comes to the data privacy rules of confidentiality and attorney-client privilege. So, yeah, I don't know if that answers your question. Do you want to ask another follow-up? Or?
There's a lot of considerations.
Yeah. So what does that mean? Should you just not do this stuff? I think everyone is, obviously the ROI is so high right now and like building these things that, you're gonna ask for forgiveness instead of permission in a lot of these cases. You're gonna hire, hopefully, a lawyer and get a good friend who happens to have a law degree on your team, soon. Maybe get an advisor for like a small amount of equity. I do this for teams. I'm not just off saying I'm gonna do it for all of yours, but I do this now more, where I will take like a % or 2 of equity for being an early stage advisor to try to help map some of the risk for certain very highly regulated spaces where AI tools are going in place that I think are going to be winners. So, yeah.
Like, is it mainly because
Yeah, well, I think that if it expands more directly, it's probably going to be a limiter and more of a regulatory burden kind of expansion, because there's going to be more effectively in the market. People are going to find out about through news or word of mouth about terrible things that have happened where there wasn't good governance or forethought on how data was used and stored, and then citizens in a specific state most often are going to lobby to get a law put on the books to protect them from that kind of use of data in an AI context. And it might just not trigger any other existing state law. And in fact, if I was going to be a betting person, which I'm not a gambling person, I would say that some states that are more conservative on passing these laws for just data privacy and protection in general might jump on the ship if they start seeing usage of AI that goes against principles of like personal freedom or privacy that are very important in some of those states. So for instance, in Texas, we have a Biometric Information Protection Act that is very stringent and strong and very protective of Texas citizens. And you wouldn't expect that Texas would have one of the strongest data protection laws on the books in the United States. because it's a live free and die kind of a place, but it does. And so as a business that is going to potentially store any kind of biometric information of a person, which now includes video recording and audio recording, Texas is actually a hard place to comply. Yeah, go ahead, Carter.
Related to the block security camera that I believe the mayor of Austin, Texas wanted to install throughout the entirety of the city. I didn't know that. Is that even legal to do?
So I was asked by Carter if the citywide camera system that the mayor of Austin wanted to put in place would be unlawful under the Biometric Information Protection Act of Texas. And I hate to be a lawyer, but it depends, right, is the answer, because how they implement it. So they're going to have to put in a ton of very prominent signage that basically creates a consent, like a public consent. Like if you're walking through this space, you have signage appears in such a location with such prominence that it's reasonable that you had the option to then opt out of being recorded rather than opting in. And then it needs to tell you the extent of what is being recorded. So this sign is getting very long and very common, you know, and so it's kind of becomes visual blight in a lot of cases that a city mayor might not want to effectively attach his reputation to. And then how long it's stored. And typically these kinds of biometric information protection acts, and Maryland has one, require that any kind of recording be deleted as soon as it's no longer necessary to maintain that data. So again, keep it for the limited amount of time as much as possible. And so if you don't, that alone could be a violation of the act that creates, in some cases, criminal penalty if it's an audio, as well as a visual. Visual, actually in Maryland, it's maybe even a little bit easier to get crowd consent by putting up a sign and then allowing everyone to know that they're being recorded. But as soon as you add audio, there's this two-party consent law that pre-exists that's on the books, and it's been here for a long time. It's about wiretapping, quite frankly, and probably came out of some of the political shenanigans that have happened in the state in the past. And so in Maryland, you have to have both parties who are being recorded aware of the recording and consent to be recorded, or you could be charged with a felony in this state for having recorded without both permission. So, knowing all of that, can I put Startup Shell on the spot? In theory, if we were recording in any space in Startup Shell, we would want to make sure that everyone is informed of that recording. I have given my consent to be recorded right now. Everybody in this room is potentially the back of your head is being recorded on this camera, and all of your voices could potentially be picked up on my audio. By being present here today, you could say that you physically consented to that recording. You're aware of the camera, you're aware I'm being recorded, that this could happen to you. But in theory in Maryland, if you felt like this information, this data was then posted on the Startup Shell website and you didn't provide your authorization for it to be permanently up there, right? It's never really taken down. That's not a de minimis use. That's not the minimum amount of use of that for whatever purpose. You could try to say that my significant, substantial part of my voice or my physicality without my permission was recorded by Startup Shell and put up online, and they need to take down all parts where I appear immediately, or I could sue them or try to get them charged with a felony. So one thing we could do is just put up like a notice, or like on the Discord or wherever everyone agrees to be. That's like a sign at the door, your voice and vision could be recorded. Yeah, and you release Startup Shell to make those recordings and to store them permanently. Yeah, so the community guidelines aren't bad, but it has to be reasonable that you could have seen it and that it was put in such a prominent place. So this would be a great law school case study, like for a law school exam. Is that sign sufficiently prominent that all of you could reasonably expected to have seen it and read it and consented to all of its terms as related to whether you could be recorded? I would love to be the plaintiff's attorney arguing that you were not for the purpose of this. So hopefully right now, hey, can we all just say I consent to be here and have like ambient recording of my voice? Does anyone not consent to have their voice recorded as part of being in this? All right, so we've all consented, we're clear, yes. But in general, if there are any other instances in Startup Shell where people may or may not be recorded, just a thought that we should probably talk about that or look into it. Okay, so that's why AI law is complex. And then add to that, right, we just talked about how this is federally, the executive branch is now coming out with a series of opinions, right, and executive orders about this stuff. And so I've got so much that I don't even want to write them all down. But I just want to kind of run through with you what some of these are. So just in 2025, right, we have had, I think, 6 executive orders on artificial intelligence. The first one was removing barriers to American leadership in artificial intelligence, which main purpose was to reestablish that we are not scared of AI in this country. We're not just looking for safe AI. We are looking for AI dominance. These are actual legal terms used, dominance in AI. And as a result, any existing executive order that was put out by the Biden administration related to needing to safeguard AI before, or urging regulatory bodies on the federal level and the state level to put in place measures to safeguard AI should be overturned and are overturned. And in addition, anything that could create bias of any kind in AI should be removed, including bias that is DEI oriented. And so they sort of classify DEI elements in executive orders and laws as almost like a form of bias in a strange way. And so that all of those DEI expressly has been carved out as an area that if there's any DEI regulations on the books in the federal branch, they should be cleared and they should be voided. And then separate from all of that, that any blockers on energy policy or environmental policy to rapid expansion of AI, including rapid approval of data center development, those are immediately voided unless they get special approval to be extended for only up to potentially 5 years, and only if the agency head overseeing that regulatory rule or opinion approves that for somewhere between 0 to 5 years. But effectively, cleaning the house on all of the energy and environmental policy related to most things, but certainly also to anything that would block AI development and rapid expansion. Yes?
For the DEI, does that mean that if while training like an LLM and they try to make it so that the data set was more balanced in terms of like the racial demographic as well as the gender demographic, that in and of itself would be seen as well?
So that's a great question. So the question, and what was your name? Say again? Michelle. Gotcha. And Carter, I think you talked 2 more times at least. And Ariane, you talked like 3 at least. Okay. So Michelle asked a question about, does this executive order mean that if there is actual DEI effort to be more balanced and unbiased that has been purposefully coded into an AI system in the commercial sphere, right, anywhere in the United States, does that mean that it is now illegal or unlawful to do that? And the good news is no, it doesn't reach that far. The executive power does not reach that far. That would actually have to be a legislative act by Congress. This executive power extends to the operation of the executive branch. I mean, barring the Copyright Office, like whether that's quasi-executive branch, we're fighting over that, or it's legislative. But in general, they control their branch. And so the scope of that reach is to any governmental action of enforcement or any system developed for government, of course, and any AI tool that is making any decisions about enforcement or governance. If they have any of those elements in them, they effectively need to be scrapped or certify that they've been removed completely, including hiring, including awarding bids, contracts, government contracts. So lots of cases potentially going to be fought over if that is also illegal in some way, maybe unconstitutional in some aspects, but that's where we stand at the moment until all of that legal fighting is resolved. So it was a major rollback and a very purposeful one. I mean, expressly talking about DEI was that one executive order. What else can I tell you? Just so that you're aware, right? So another executive order that relates to AI is we now have a executive order that the executive branch is supposed to work actively to help export the full stack of the American AI technology stack. We want to send hardware, software, full stack as far as we can to our allies abroad. And we're not going to try to protect IP to the extent that we aren't doing that. And I think that's more for trying to compete with DeepSeek and like making sure that the licensing and the expansion of our customer base being global is not overrun with other international offerings that are comparable now and able to very freely license their technology and put it in place in any commercial context and also governmental one. And this was a little bit controversial because there was always a risk and a fear that if we spread this too fast, too quickly, that it could be reverse engineered, it could be used to support governmental aims of other countries that are our allies, but we don't agree with all those governmental aims, right? And so most of that has been simplified and cleared at this point. Politically, whether you agree with that or not, up to you. And then there is one, and this is actually one where it also expressly talks about DEI. Preventing Woke AI in the Federal Government came out in July. This is the actual name, I know. So this is probably like a direct concession to the base that got this administration elected, which is very focused on this word, woke. And what does that mean to them? That means that federal agencies have to review and revise, again, procurement policies. That's who they can hire to do government services as an outsourced company, to ensure that AI systems purchased and used by the government are ideologically neutral and free from engineered social agendas, and requires the NIST framework, both the AI framework and also the cybersecurity framework, to be revised and rewritten to remove references to DEI completely. So, wild times. Wild times. Now, again, there's, if you disagree with this, vote. Vote, and also contact your legislators who don't have power over this, but can try to pass laws to respond, right? So that is where we are with that. And that is our overarching federal law, because we do not have a comprehensive AI Act in the United States on the federal level. Instead, what we have is a patchwork of state law. And the one that I am going to flag for you, since I know we're probably running a little bit long, because we always do with Juliana Talks, right? Let's see. Oh, 7:06, I'm good. I'm solid. All right. The one that I'm going to point out to you is like the high water mark is the Colorado AI Act. It's got a longer name, but this is the one. Colorado, interestingly, again, not always seen as like necessarily like this is a law that's notable because it actually puts in a lot of regulatory limits on what you can do and build with AI in the state of Colorado. Similar, but not as in depth as the EU AI Act, which I am not going to cover tonight, and I could cover separately if anybody in this room is very interested in expanding into the European market. You definitely need to think about and talk to somebody about this, or have someone like me come and give a presentation on it if a lot of you are looking to expand your products into the EU. But this one is the high watermark as far as the most restrictions on classes of services that you're going to provide with an AI-backed system. And I say restrictions in that they have 4 categories of protection, and based upon whether they've deemed the service that you're providing, the data that you're collecting in order to provide that service as being so sensitive and high risk to have AI handle that they either completely bar it for a commercial company to use AI for, or even national governance can't do it. Things like capital punishment decisions or sentencing in most of the EU cannot be decided by AI, which seems like a good idea. Certain life or death treatments in the medical space can't be performed by AI. Deciding who can be released early from their sentence cannot be in most countries in the AI in most cases. But then they have other levels that are more secure. So again, providing any kind of health services or medical services that you might be using with an AI backend in the EU, you're going to be in a higher category of regulation, which means you have to track more information about what you're doing. You have to create more logs about what you trained your AI backend on, or the inference that you did, and like the various stages of that. You have to otherwise comply with all the GDPR data privacy laws. You have to establish a period of testing, periodic testing on a schedule that meets those requirements. I mean, there's just a lot of little requirements for that. I saw Carter's hand first. Did you want to go first?
Yeah, so for like life-saving treatment that AI can't do, like if it was risky, is it a matter of risk, or is it a matter of what's the differentiator? Because if there's a treatment that an AI can do better than a human, but it is a very risky procedure, but the AI is better at it, would AI still not be allowed to do it because it's a very risky procedure?
You would need to very carefully define so that you don't hit that category, and then make sure that your practice actually reflects what you've defined as what you're doing. But in many cases, you might be completely barred. And so this is why maybe we're not going to have some of that activity and research happening in that jurisdiction. And this is the argument of our current administration, that we're going to try to make it, when our administration is not going to pass a lot of restrictions and rules similar to this, we're going to go away from this. The last administration was really reviewing this in detail. Of it rather than less. Current administration says we are going in the opposite direction of this, because come to the United States, do your research here. In general, when we can, we're going to say yes. Right.
That does not count in any way as like infringement of copyright or like stealing their data and using it.
Right. It was sufficiently transformative use to take elements of an image and recategorize them as mathematical weights, and then tokenize that in order to then run whatever system was going to.
Since the AI lab was going to be storing the weights,
Yeah, storing only the weights. I'm just telling that on the camera, not the actual images.
that seemed like really like groundbreaking sort of ruling. Everybody's arguing that. I think the New York Times argued, and Reddit argued. Everybody argued.
This is a session.
Everybody has been arguing that whether or not using information that is public, whether or not you get a license, you can have access to as much data as possible.
Okay. So I'm kind of getting nudged by the crowd to go ahead and start talking about like practical application of specific other areas of law, like copyright and like input data, output data, all of these very like the new developments and where do we stand. And I want to get there too. And so let me just say, let's talk about copyright in the US first, and then we can also talk about the EU a little bit too. But before we get there, I just want to make sure if on this topic, if there's anybody who had anything else. But we're getting there. We'll answer that question, I think. Go ahead.
Yeah, this might be a pronunciation.
Yeah, it's good. Let's go. Ask it.
Okay, so
We'll cue it up. Yeah, no, excellent question. You're right, your instincts are right that since we don't have a comprehensive US AI law, it doesn't specifically tell us what the status is about using student records to train an AI tool for like an educational purpose, or once you have users on your AI platform who are inputting information and getting outputs of lesson plans or gamified information or training or school records tracking and updating. There's no specific federal rule that's an AI specific rule on that. So we do have to look at these other existing areas of law. And the data privacy rules on this would actually be, there are a couple of federal rules that would apply. So one of them is COPA, which is just in general for anybody under mostly it's every child, but the higher risk category of kid triggers at 13 years old and younger. And then also, if it's got school records involved, grade reports, performance reports, and it's tied to a specific student, then we're talking about FERPA. And if you're managing that, for instance, for a school system or a teacher or a tutoring company, you might be triggering FERPA. And that is existing long-standing US law. And how you capture that information, how long you store it, how you make it possible for the student to edit it and review it, or their parents to, those are things that, again, you could create a checklist to just see, hey, am I in compliance? I would start, I'm not saying that you should solely rely on a GPT to be your legal advisor, but I do think it is useful to just try to get a checklist on some of these laws, because what's going to end up happening is you're going to say, oh, I'm not seeing anything I'm triggering. I'll just talk to someone like Juliana or someone at the Dingman legal office hours, and something free on campus ideally, and just confirm my intuition that I'm okay. Or you might see 2 or 3 things you're like, oh, I trigger those. I think I can comply, or I can't at all. I need to go talk to someone potentially to just figure out if I need to pivot my model or how much risk this really is, and weigh that and decide what to do next. So in your case, I'm betting you might have a FERPA thing, not having heard more, and you might have a COPA thing. If anybody who's inviting users who are under 18, but certainly under 13, is going to want to get a checklist to make sure that they're in compliance with COPA, for sure. All right, so those two, and then you have a follow-up question. Go ahead.
So then there's personal data that's attached to the student, but then what about the product that the student is using? Let's say the student is flying a drone inside the classroom, and let's say that company.
I'm so sorry, online people. I know that's hurting my ears. Go ahead.
Okay. So the way I see it is there's 2 different types of data. There's personal data that's attached to the student, and then there's data that's attached to the actual physical hardware product that the school bought.
Right.
So my question is, what are the laws or the litigation around having a company having access to that data that's attached to the hardware or product for them to use personally to improve their own, whether it's their own services or product or whatnot?
I'm going to try to rephrase that second part just to make sure that I get it. So, and when you say the data attached to the hardware, or not the hardware, but the underlying application and not the specific student record, are you meaning the training data set or the data lake of all of your students together that you use to constantly update and modify and run tests on your system?
I would say the latter.
Okay. So then in that case, yeah, some of these rules would still apply. In fact, they very much apply in those cases, as far as how, especially one of the best first steps you can do is whenever you can anonymize or pseudonymize a data set from only your user can see what, encrypted, and end user can see their personal and identifiable information or their other activity information attached to their account that might be covered by some of these. When you pool that into a big data lake that you're then going to use to update, refine, improve your system, very often you can reframe a user as a code, and then also even summarize a lot of their specific user activity information so that it no longer is triggering these rules, but you can still get all of the upside you're looking for further development and improvement. And then a lot of the user logs that you care about are how long on site, and did they complete an assignment? Did they follow a full user pathway or user story in the way that we expected, or did they not? And a lot of that is not going to trigger this kind of information unless it's performance related for a student. So that's the one tricky area. Yeah. Go ahead.
Is how you package that information like more important than in terms of if you package it in a certain way it won't be.
Yes. So how you package that data, how you store it, how long you store it, if you reclassify, if you anonymize certain aspects of it, all of that is very relevant to whether or not you're going to be triggering a higher regulatory burden for how you store it, or if you're violating these laws outright. Yeah. Yeah. Hey, yeah.
So what if everything's anonymized, but you have some really woke things, like gender mark or like racial identity?
Yeah.
Is that in violation of that? If you use that to
I gotcha. So she's asking, and I think I'm going to say this, and I'm going to try not to smile because we just talked about the executive order on this. So she said, what if you are creating this data set in your app, or your app is collecting this a lot of different user data, and some of it is this targeted under the executive order about anti-wokeness, DEI-related information, and attributable to that user characteristics that would fall under that category. Is that now going to be in violation of law? Did I get your question? Yeah. So again, remember that executive order was specifically for activity of the executive branch, how it runs, what it does, how it executes on delivering to constituents, all of us, their specific services. So if you're a government contractor helping the government do those activities in the executive branch, you might be in violation of the executive order. If you are doing that fully commercially with an end customer that is also not a government contractor using your tool for that purpose, then you're probably okay, right? And then it's just if your state decides in the next 10 minutes to pass a similar rule. Yeah. And it's not challenged in federal court under constitutional law. So we'll see. We'll see how this all plays out. Okay. So the other area of law that I didn't put up here yet was employment law. We do have kind of half and half where there's actual AI laws that are in the employment law arena that have been passed, such as in the city of New York, in California, that specifically talk about when and how you can use AI, and most often when you can't, which is actually very similar to the EU AI Act. There's a lot of restrictions that are being putting on, or prohibitions on using AI. And I think that we're going to see in this arena, even under this current administration, it's going to be difficult federally if we're not passing AI laws to also, they're not going to be able to block state level laws. And so I'm going to say that the trend on this is very much going to go towards more and more cities and states are going to pass rules that actually block your ability for using AI backend for screening candidates, recruiting candidates online, making hiring decisions, which candidate wins, performance reviews done almost completely by AI backend or largely doing that, and then terminations. Oh, promotions. So any of those kinds of features, hot button, already on the books in certain jurisdictions in the United States as being barred or embargoed on being able to be used in those contexts because they're just considered too important to our economy, to public policy, to keep those done by humans and not by systems that could be flawed or biased. Questions on that? All right. Seeing none, let's talk about, we talked about Colorado a little bit. We talked about how it's similar to the EU Act. I didn't actually go into too much detail here yet. I could, but I think we should actually talk about what's new, because this I even talked about last time I was here, so maybe go back and watch my talk from last time if you're interested in this one, and I can also come back and talk about it more. But let's talk about what's been going on with case law and in the last couple of months. So I mentioned to you that copyright law is like a really hot area, and this relates to how you build your tools, what they output, how you train them, and what users can expect to own at the end of that process, which is all very important stuff if you're in the business of this. So the Copyright Office I mentioned has, and we're going to get back to this, I think, by virtue, it was you, I think. Yeah? No? Who was the copyright? Yes, sir. we're going to get back to this now. So I think we've kind of covered this one. We'll talk about the Getty image. So in the United States, we have an uncertain copyright office right now. And I'm smiling because it's unprecedented. It's exciting times in the legal field. It's exciting. You put aside your political viewpoint and just say, I live in exciting times. So, so copyright in the U.S. So what did the Copyright Office say before it was somewhat dismantled, right? As far as how they believe future copyright rulings, they're kind of saying to the courts, here's what we would support as the Copyright Office in our interpretation of the laws that we oversee. Judges can do what they want to do. This is not enforceable. It's not an official opinion because we didn't get through that full approval process before we had our leadership dismantled. But here's what we would say if we were advising judges. And at this point, the Copyright Office actually had certain elements of what they advise that made the large GPT companies very happy and felt like they were very friendly to them, more than they expected. And I will tell you those elements. And they also then had a number of elements that were very protective of copyright authors, the people who actually create the works that may or may not get pulled into these large data sets that are used for training and abstraction before they potentially transformative, sufficient to the point that it's not going to trigger anything but a fair use or a de minimis argument against copyright infringement. So, so let me I just actually want to read to you what some of this was. So the Copyright Office, so some of the elements that are being protected are that there is an expectation that transformative use is possible. So what you were describing, where we take an image and we break its components down into subunits, right, that then have a numerical scale attached to them, that then can be used to train en masse a system. And sometimes those components can be combined again to come up with a similar image, but that is not because they stored an image on a server somewhere and then spit out the exact same image from that data set. It was because the combination of and I'm forgetting the tokens, like, the token triggering happened to go to a pathway that gave a similar image to the originating image that was otherwise fractionalized and broken down, right? So in some ways, the report, not an opinion from the Copyright Office leadership, said, we can see the argument that this is transformative to break down, tokenize works, and then quantify, turn them into a quantitative system and framework. I mean, what would be more transformative than that? Can we even think of an example that's more transformative than that, right? Like, it would be hard. So if we don't allow some kind of way to do that, even with images, which are one of the most protected forms of copyright, most expansively protected, then we basically don't really have a transformative element to fair use that we can point to. And that seems like, why do we even have this element? We're basically saying we don't believe that transformative use is a fair use argument. But there are 4 prongs to fair use. The transformativeness of the resulting work from the originating work, or of the use from the originating work. In this case, it's use, we're not talking about the end output, just the use of that work without a license. There are other elements, and one of the 4th element actually got a lot of attention. There's the middle element is, how much of it did you use? Did you just use the smallest part you needed to, right? And there's a whole other area, part of the Copyright Act, where it talks about how every digital image has, has effectively like a digital fingerprint. And if you strip out, which the AI backends do, right? The GPTs strip out these CMI data, and they very often, and then they just want the most simplest version. They just want the image themselves. They want the sound file itself. They don't want the record of where it came from, who the author was, the attribution, the time. They don't need all of that. That's just bloat. So they strip that out. That actually is violating copyright law to strip that out. The act of stripping out the CMI data and not having it attached to what you used is the violation. And so there's this area of copyright law that rarely got litigated is now rising and spiking because of how GPTs are being trained on data that's been stripped of their CMI data. So that's one element that's also still supported by the Copyright Office, or at least not. They haven't said that they think that that unbundling from CMI data is being overused in courts. But the last prong, before I go get your question, is the effect on the existing market for the author. So the commercial market being shrunk effectively because of your use. And in the case of training a GPT model to be able to output, in many cases, very similar works to your Studio Ghibli design, anime characters, right? Like that is, and then people can literally put in your brand name, your trademark, and then get back what appears to be very similar to your copyrighted works. That seems to be potentially replacing some of the market, potentially shrinking it, or even devaluing it to the point where in some cases artists and photographers and filmmakers are worried that they will not be able to sell as much. And that seems to be somewhat of a persuasive argument to the Copyright Office. Yes, you both had a question. You were first, sir.
I am curious as to how this applies to stuff that's not images. So if I decide to go and scrape Reddit or Twitter and accumulate all this data, often the person who's writing the tweets, like they themselves are posting under an anonymous account. The usernames aren't always very nice.
Yeah.
And would I have to include that in my training data?
Okay, so the question is, I want to scrape Reddit. Does that apply in the same way as like an image scraping of photographs by photojournalists or famous photographers or paintings by visual artists, right? And the answer is actually the type of the work does affect the analysis of that fair use to the extent that, the originality in the work itself does affect. So we consider like these visual works to be highly original. Almost 100% originality is baked into them. A musical work very often is that, except for chord progressions under the case with Ed Sheeran actually proved that chord progressions actually are kind of universal, and you can't, it's going to be hard to block someone from reusing chord progressions. But you're talking about Reddit. That, on the other end of the spectrum, is like the copyright that you can get in for creatively collecting facts in a new way in a collection. And most of that is facts, and very little of it is, it's mostly data, and it's very little originality in that. And so it's easier to copyright that and say that you are transformative enough, you are not, the nature of the work itself is such that it is inviting, many people to come up with different versions of it without violating copyright and having a fair use. So Reddit, that's a great question. So we would actually have to look at the facts on that one. I would say that we would look at, we have plenty of examples of social media content creators submitting a collection of all of their posts to X or Instagram. No, let's take out Instagram because it's so image to X, which are all text, and submitting them as one big copyright so that they can enforce that copyright against others who want to reuse or repost their X comment without their approval. And that gets through. That's long enough text that it's considered enough to create some originality, and it's not just such few words that it's just a phrase in English. Reddit could definitely, in the length, also fall under that sort of X analysis. But the purpose of X is for people to put out their ideas and their opinions and to express their originality to the world, to take an idea, right, from their head and fix it in a tangible medium, which is X. The question is that the purpose of Reddit? Is that what people are there to do? And I would say that we would argue, if I was your attorney, I would argue hard that actually Reddit is just about data and information sharing. It's not about creating original works. Most of the commenters are not there to create something that they expect to be able to protect as an original fixed work, a copyrightable work. They're just sharing information with other people. And so I think you'd have a stronger case. Now, All that being said, you have the layer of the contract law that I haven't even got up here, which is between you and Reddit. And Reddit's terms of use and terms of service are very likely to have some kind of restriction on that kind of activity. But sometimes they aren't. I don't know Reddit specifically. I know LinkedIn very much tries to bar you from scraping it in any possible way, and tries to basically say, we have the copyright in anything that isn't owned by a specific user, and we do not give our copyright license to you to scrape LinkedIn ever under any circumstances, and we will shut you down and potentially litigate you if you try to.
If I'm not wrong, I think Reddit has a deal with Google to allow them to scrape as much data as they get.
Yeah, it could be. I haven't read the terms of service for that analysis, so if Reddit allows, it might allow. Somebody else was, Carter, I don't know if you were second. Somebody else over here, I saw you. Okay, I got you. Yes, Carter, go for it.
So, if there were suddenly 100,000 artists who decided to work for dirt cheap and could produce Studio Ghibli style art, would that violate the market value clause?
The market value. Okay, so the question is, if there's 100 really talented artists, or reasonably 100,000 reasonably talented artists, backed up by not using any AI, just humans creating works that are similar to, purposefully similar to.
Not perfect, like the same way they take requests from customers.
They take requests from customers.
And this requests are the same that would go to ChatGPT.
And they take the same requests as go to ChatGPT, but then they produce, the humans produce. If then we look at the prompt. If the user prompt to the human artist says what is very often said to ChatGPT, which is, create this image, but make it in the style of a Studio Ghibli film or a specific character from like Ponyo or whatever, then that would be an unauthorized derivative work, because you don't have a license from Studio Ghibli to create that derivative work, and you're purposefully trying to recreate that work. That would be the starting point. Because they have copyright, they are eligible. They may or may not have registered all of that in the United States. They probably have, because they've licensed to film companies that have distributed in the United States. Netflix at minimum, I think, has that, and so, or maybe HBO, I forget which one. I think it's HBO right now. It's probably made sure all their copyrights are up to date. You have not, your team of 100,000 humans have not gone and gotten a license from HBO or Studio Ghibli to do that, and they have that right, and that is protectable. So then the question is, we look at the fair use prongs, right? Is it transformative? Probably not. It's a little bit, right? You're creating a new scene using existing characters, or maybe even totally new characters, but that look strikingly similar, to the point where it's purposeful that you want to call back and reference that specific style, so that others who see the work that you've created, and you yourself, get the joy of seeing a Ghibli style character or scene. That's not transformative, right? It sounds like you're purposefully trying to basically get a Ghibli studio work out. Then we look at the nature of it. It's a visual work. Bad fact for you, visual works inherently broadly original. We consider it's very hard to say which part of an original work, where does it start and end. It's very difficult to say. We even have cases where, like, down to the pixel, what if I take 5 pixels of a visual work? And we get down to that level because it's so hard to say where it begins and ends. Because the moment it's recognizable as another person's visual work, or a film work, then it seems like it's not so transformative, is it? You're getting the full benefit of having stolen it, even by taking a small element. And then we look at let's go directly to the commercial element. If you're going to use it in any commercial context at all, then you for sure you're getting some of the goodwill in the marketplace for that studio, and shouldn't the author be have the sole ability to get that benefit in the market? They've built the brand up. They've built up that quality. So you've got your hand up. Tell me.
So my question is, can you trademark a style of drawing?
You can copyright this. You can copyright the work, and then that effectively the style can be considered a derivative work violation. You can get protection over, and then you can trademark specific characters as like part of your logo. Or yes.
You never made the characters.
I'm sorry?
If you never produced the same characters, they never looked alike.
Yeah. Then it's harder to claim a trademark claim for them, but it's still probably likely they could trade copyright, especially if you do the the killer thing of putting in your prompt the name of their studio or the name of one of their films or the name of one of their existing characters, which is often how you get the output. So
In a sense, it's not the copyright as on the training itself, it's more so on the output. And if you're relating it to a machine learning.
I mean, honestly, it's somewhat of a violation. I mean, on the training it is too. It's both. We look at both. There, you as a producer of these works, as an app, let's say, you could get hit with copyright infringement claims and a case on the front end for the misuse of training data without a license, without a fair use exemption to infringement, and on the output, both your user and you could potentially be joined together for that violative output.
Sorry, I have a quick question. But my last one.
Yeah.
What is the difference between like a human viewing an artwork and a machine doing the same thing? Because granted, in one that
Oh, I
we're
love
not
this.
saving it, not saving it, more so than your brain would save it.
Yeah.
And it is simply viewing it, and then that's it. Like it's looking at it, it's maybe getting some idea of what it was, the same
Yeah.
way a human artist would.
Yeah.
And a human artist is not charged with violating a ULEF for watching a movie and then drawing something that they like that looks similar to the movie.
Stop there, sir. So the case study that we're getting as a follow-up is, what is the difference between a machine viewing these works for the training purpose and a human artist viewing these works? And then both of them remember that, however they do, whether they transformatively break it down but still remember it when they put it back together, or as a human, it's in the subconsciousness or the consciousness of the human. In your case, you said there's nothing wrong with a human remembering that and then recreating that later. Yes, there is. That is a violation of the copyright. For a human to make a derivative work, an unauthorized derivative work, by trying to redraw a character, it is a violation if you do that without a license. Most of the time that's not enforced because it's a child or you at your home, nobody knows. But the reason why we're talking about this, and again, if your GPT does this, a lot of you have done this, right? You're not going to be sued in most cases because you're not trying to commercialize. The moment that this becomes a big issue is when you as a user take this work and try to commercialize it without a license or a fair use reason. And if the GPT provider that is doing this for all of us in our homes without us it being aware, if it becomes clear, which it has been in the news and in courts, that they are purposefully allowing their outputs to include these infringing works en masse to the point where none of you have to go see a movie. You can just create a movie in Sora. You can create the next Ghibli film in Sora in 30-second increments, very painfully. Has anyone else used Sora? Yeah, it's so painful to try to, like, I have a long narrative that I'm trying to, it's so painful. But anyway, but you, in theory, could do that. That is all, if the system itself is allowing that, that's violative. So the other big element that has been coming out of the case law in different federal courts on these copyright outputs, as well as and the training inputs, really both sides, as well as the Copyright Office is reinforced to a certain degree, is that guardrails. So when you are training your system with any kind of copyrighted material, even if you're Anthropic and you just are chopping up books and doing it that way that you've purchased, or films that you have license to, if you put guardrails in your system so that the outputs can't just allow someone to create a copy directly of a prior existing work that you've trained on, or of a certain style to make an unauthorized derivative work, that is a great fact to show that you as a company are actually not in violation of copyright law. And you can get your case dismissed, which has happened a couple of times in specific cases. That, again, I can give a list of cases afterward. I just figured, like, you guys can all see the cases online, but I can do that as well. So I can do that, Bobby. All right, I got 7 minutes left. Oh, we're 7:43, so we're done. We're over. Is the camera off and all that? Okay, so so the point is that putting guardrails in that show that you are making a good faith, reasonable effort to prevent your end user from using your tool as a copyright violation engine is a great fact as a defense against copyright violation for you as the entity. And unlike the social media companies that are saying, we're not responsible for what's posted on our platform unless, we're alerted. For the time being, there is a little bit more of an enforcement bias, even in the United States, in federal court, to support allowing the case to continue and not just be immediately dismissed as like, this is not a real viable case. If you haven't put these guardrails in, if you haven't taken reasonable steps to try to oversee and administrate your platform or your agent or whatever level of that stack you're building. I saw you. I thought there was one gentleman over here too, but I want to get back to you if you can. All right. That's such a great question. So he asked, can we leverage public domain copyrighted works of authorship from the past that are now out of copyright? Yes, they're in the public domain. You can modify them, use them, slice them up, go wild. But I will say this, when you create new works from them, or your end users do, your copyright protection in your ending work is limited to the parts of the work that you added. If the core majority part of your work is just finding this really cool, let's say like audio file, and you sample it, you actually can't block anybody else from playing it, recording it, reusing it too, like you would if you had made the whole work. So it's nice to use that in a very small, discrete way. Like take the best parts of it, but like add a lot, make the majority of the work something that you can protect if you can, if that's important to you. Yep. I'm going to come back to your promise. I think you're the head of the class. It's either you or Carter. I'm going to call it a tie. But go ahead.
So I have two questions.
Yes, ma'am.
Firstly, someone's likeness or face or image, can that be protected under copyright? And if so, are there any protections from AI from violating those sort of copyrights?
Yeah, this is great. So we had name, image, likeness, face, image, likeness, voice, all of that bundle. This has been a super fun, I'm smiling, 'cause it's also been a super fun area of law that's been developing rapidly over the last 5-6 years at the same time as the rise of AI law. And we've seen this in entertainment and sports law be very important because we have collegiate athletes now able to commercialize, which they couldn't so freely before. High school athletes can commercialize. And so name, image, likeness rights are very important. So you can, in some cases, most of the time we're going to see protections under trademark for your name, image, likeness, because it's things that are naturally occurring aren't a fixation of an idea, right? You could try to argue that if you take on a name or there's a character that takes on a name that is just really associated with that work, and that work is often fictionalized and it's sort of separate from the reality of that individual or that person, that you could try to protect that under copyright. But in typically copyright, it's very difficult to protect a name. You're more likely to get that under trademark, but very similar analysis applies to what we've talked about. And in that case, you still have your trademark rights extending into AI platforms and tools. And so the same breaches that we've been talking about under copyright, very similar analog to trademark. And if they train their system specifically on your trademark name, image, likeness without your authorization and license, then you could have a claim similar to copyright with the same regulatory teeth. Copyright law exists the moment you fix into a tangible medium your idea under common law in all states. The statutory big penalties that you can get under that get litigated arise when you file and register with the federal government, but you still have those rights. Trademark similarly is often on the state level. You can register there, or it arises in some cases under common law just because you've been prominent and you've created goodwill in your name, image, likeness, voice. But you also get a lot better penalties and teeth in your ability to enforce if you register that trademark on the federal level for all of those elements. This is it used to be like $36, and you could even register a collection of things under one, like a data set, under one copyright filing. And so it was just very easy to self-serve. You create a portal for your business and upload every application you want. This is more like $345, $350. Maybe it's actually gone down in price to like $245. Anyway, a little bit more expensive, a little bit more complex for how to draft it to get the protection you want. So you might want to, again, look at some of the campus resources or hire an attorney to help you with this. Patent, wow, definitely get outside assistance if you can. I mean, most of us in the room are very smart and could handle certainly filing a provisional patent application, and I've had students in the past who've done that. But if you're going to do a lot of patents under a regime, or you know you want to commercialize in a lot of different contexts one patent, it is a really good investment to get a patent attorney who has experience with thinking about the end commercialization and where the value lies in your patent, so that you're protecting the right things and not having to spend money patenting something that, yeah, there's ability for you to take that part of the land of patents, but like it's not actually protecting what the real value is in your business, if that makes sense. I don't know, that might be a little too subtle of a point for tonight, but get an attorney for sure. Probably have an attorney at least look it over. You probably can file this on your own, shorthand. Cool? All right, I'm coming back to you. Haven't forgotten. Yes, sir.
When we make it terms and conditions for users, right?
Hey.
When do we have to mention that we are compliant with like Colorado AIA, this AIA, that AIA? Is it implied that we're taking every act into account and making our product compliant?
Such a good question. So he says, when we make a terms of service, terms of use, terms and conditions, and a privacy policy, please do both. Separate out the privacy policy from those terms. Just do both of those things. Just trust me. Do I have to cite every jurisdiction's actual legal act and rule in order to be in compliance with that legal act and rule, if I otherwise just put in the terms in my terms and privacy policy that show that I'm complying with that law? In most cases, this latter is true. If you are operationally complying with that law by stating the right things, doing the right things, you're in compliance. In a few exceptions, you actually need to say, because this jurisdiction has this specific rule, I am in compliance with blah, 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 element. Usually it's like a subsection of that act. And then actually under, yeah. So this is where terms and conditions and privacy policies are like the worst thing for us to have to work on, because they're so commoditized and it's like no one reads them. Why does this matter? It is the primary contract you have with your customer, your user, and it is more often challenged than you would think, and nobody really wants to pay for it, and it takes so much time for us to draft it, because it actually is much more custom than you would think when you copy and paste your competitors and just like auto replace Control-C like your name in for their name, because it does matter where your users are and where you are and what your data you're collecting and how you're using it and what services you're offering and how you allow that to terminate. Do you do refunds? There's just so many things. And then if you're in certain jurisdictions under copyright law, you actually need to create a copyright officer in your organization and name them and have a specific email address and mailing address and phone number where people can reach them to submit a copyright infringement claim. And if you haven't done that and you otherwise are having to comply with one of the parts of the Copyright Act, which is the DMCA, the Digital Millennium Copyright Act, which just depends on what type of business you're in violation of that. And it's just like a very particular thing that you have to just know, and only probably your attorney would know unless you've just done a ton of extra research. So it is actually worth, I would say this, maybe do that initial copy and paste draft, on your own or with a GPT, and then have a lawyer look it over just to make sure that you're not missing something or put something in that is actually creating risk for you. That might actually be worth it down the road when you have legal budget.
Because I remember I'd spoken with you in around like August time, and you told me about terms and conditions for like beta testers. So I mean that one worked out. So would you say like for users like that beta?
Oh, I think he's saying I created risk for him. Is that what you're saying, or no? No? I hope not. The opposite? I helped? Yeah, I helped. Thank goodness.
I'm just saying, is that a good starting point to use, or like is it supposed to be something entirely different in terms of users for beta?
Is my beta tester terms and conditions sufficient for my public launch terms and conditions for my end clients? It depends who your end clients are. If your end clients are developers or some very similar, they have a similar user pathway and user story as your beta testers, then you probably, whatever you invested time and energy in for the beta testers is going to be the same. It really matters, what are they doing with you? What are you doing for them? What promises are you making? And what responsibilities do they have back to you? And if those are the same, that's the fine. The one thing that might be different is that your users now post-launch are paying you.
Yeah.
And so,
Messing around with the product and trying to hack.
yeah, they're not going to be red teaming it and stuff. Yeah. So in that case, you might even have a code of conduct that you add where it's like, you just say it's prohibited to do some of the things that the beta testers were doing because you don't really want them to do that. Or if they find a error in the system, they have a responsibility to notify you, so that way you have all these like trap doors that allow you to legally just shut down their account if you don't like the way someone's behaving, and you're not going to get sued for having interrupted their subscription mid-month and not reimbursing them fully. And then you also need to tell them like what happens, when is their responsibility to pay you? Do they have to pay you in full? What happens if like their credit card bounces and like can you just shut off their account? Can you freeze it? If they terminate mid-month and it's a monthly subscription, do you give them a prorated reimbursement back? Probably not. You just need to define some of those things. Money is the thing people fight over very often. Or access, if they're making things on your platform, losing access to their repo is like very much what they will fight over. If you can just shut that down and he's like, yeah, I will, 100%. So stuff like that, wherever there's like an exchange of value or they're creating value or they're giving value to you and you might interrupt that and you want the power to do that for your protection, that's something that you need to state in your terms of service. All right, we are way over and everybody is sort of trapped here in my like limbo. I'm happy to talk to you some more. You want to go home? He wants to go home. Bobby wants to go home. Okay, we could wrap it up officially, although unless you think your question needs to be heard. Yeah, I can do one last. Bobby is a kind dictator. Yeah.
You want to do a question? Okay. Oh, thank you.
Yeah.
So, I remember you were talking about how for platforms that could potentially enable someone to create copyrighted works, if you have guardrails in place that help prevent the users of that platform from creating copyrighted works, that's what you said, right?
That is a great fact. I'm not going to say it's 100% you're going to be free from any liability for copyright infringement that happens on your platform habitually, but because anytime that starts to happen, you should be trying to adjust for that if you're aware of it. But there are multiple federal courts now that are citing a decision that said if you have guardrails, then you are taking reasonable steps to prevent. And so you might be disclaimed of liability, even if your end user still might have to fight that case for having done that.
Right. So I guess my question from that is that what do these guardrails usually consist of? Because I guess that there's usually a difference between like them saying on the terms of service we do not tolerate this versus them having, I guess, platforms like YouTube that can like prevent you from monetizing videos if their detection system
Sure.
like detects something that is like derivative of another word.
Yeah. So he's saying, what are the guardrails? Give me some examples, because we have the YouTube example where they have effectively like really great analysis AI tools that detect when there's copyrighted work, and they also have aggressive reporting to them with the major copyright holder brands in different digital, visual, video, film media, music as well. The license holders are helping them. And you're a platform that, give me specifics on your platform, like what you would be doing or the case study you're giving me. Because I could answer this like generally across the entire internet, like how you could do this, but give me a specific example to.
Like it would vary from platform to platform.
Yeah, as far as like how you would put those guardrails in, yeah, of course, because it depends on the nature of the content. On that, you're upset. You feel like I didn't understand you.
No. I was just thinking because I was asking for the general components, but I realized those may be different across different
Types of works, yeah. It definitely depends. So if your platform is creating like all different types of media or works, you know, literary, musical, visual, hybrid, film, poetry, whatever, right? All of it. Then you're going to have a higher burden of responsibility putting more types of guardrails. And this sounds more and more deterministic and sort of averse to generative AI platform development. And it creates, I understand the stress of like how that's almost impossible. And like the more determinative you get as far as your developer prompting and inference constraints you put on, like the more it resists you in weird ways. So yeah, you might even have to have a determinative element for these rules that runs as like a final filter or as like a step in the process of creation of your outputs so that you can ensure that you've put in sufficient guardrails. Yeah. All right. I think we're good. Thank you. So happy to be here as always. Yeah. Awesome.